How you doing? This is Jason Patrick. Uh, I'm involved in the Oregon Ammon Bundy et al. The second trial. So yesterday, the judge ruled that she wouldn't receive oral arguments for the motions that were put forward, and so I figured we'll just make our arguments here. You know, they're not on the record, and the judge didn't want to hear them. She was in a hurry because the snow was falling, but it's basically the motions are really more about checks and balances. So we filed a motion for collateral estoppel, and most people probably don't know what that is. Collateral estoppel is where the Supreme Court ruled constitutionally you can't retry the same charge and the same evidence once it's already been adjudicated with a final judgment. And the final judgment in the first case was an acquittal. The jury found that there was no conspiracy. So you're supposed to have separation of powers. The executive branch, meaning the prosecution, and the judicial branch, meaning the judge. And collateral estoppel is a check and a balance to keep the executive branch from retrying the exact same charge in the exact same case. It's a Sixth Amendment violation. I've heard it before. Different law enforcement officers tell lawyers that, and the quote is, "We understand it's all part of the game," because to them it's a game. The justice system is a game. They try to do something, they try to do another, but if you're charged, it's not a game. It's your life. It's real life. It's not a game to me. And so to take the checks and the balances and the court system and say, hey, well, it's just all part of the game, it begins to look like that when you're in court. It looks like theater. You know, it's all for a show. You know, the judge strenuously scolds the government for requesting 6 more weeks to decide, and then lets them do it anyway. That's not a check or a balance, which is what her job is to check and balance. The interesting thing about, a fair trial is way back when in around May, I requested 5 days from the judge to sever or not. At the time, I'd only been able to see about 2,000 printed pages of 4 terabytes of discovery. It's a big giant haystack. Then they're trying to charge me with an imaginary needle. You're not even sure if it's real. And I'm responsible for 26 other people's every statement they made in a conspiracy charge. So I wanted to see just a few more pages than 2,000 and asked for 5 days. And she says, nope, deadlines are deadlines and we got to move forward. And then you fast forward to now, since May, all this time, and the government says, well, we need 6 weeks to decide what we're going to do. And she scolds them and then says, all right, go ahead. I don't see how that's a check and a balance. And I don't see how it's fair. All I wanted was 5 days. For my speedy trial from the first time, no, you can't have it. And now they request 6 weeks, and she just ultimately gives it to them. So the purpose for the motions is to give the judicial branch every opportunity to act as the check and the balance that they're supposed to act for. Most people won't know what collateral estoppel is. It's basically a check and a balance that says you can't retry the same evidence on the same case. It's an identical charge that's actually been litigated with a final judgment. Those are the rules for collateral estoppel. It's an identical charge that's actually already been litigated with a final judgment rendered. Its purpose, it's designed to prevent legal harassment, like just continuing with frivolous charges against the same people, and abuse of judicial resources. What good does it do to spend all the time, energy, and money, waste the judge's time, the jury's time to retry an identical charge that's already been litigated with the final judgment rendered? It's legal harassment, and abuse of judicial resources, and the purpose that it's there is for a check and a balance for that not to happen, but only if the judge actually looks at it and does her job. Courts are supposed to be hesitant to do it, so not in every single case, but in unique circumstances. And I would think this is one. This is a pretty unique circumstance. It's worth looking at. The case law is Ash versus Swenson. The Supreme Court made a double jeopardy application precisely for crimes committed at the same time, at the exact same time. So the crime alleged is at the exact same time, the exact same people, the exact same witnesses, the exact same meetings, the exact same everything, and we're going to just relitigate it again. So in this unique circumstance, it's worth re-looking at the evidence. There's not going to be, there's no new people, there's no new stuff, it's all the same thing. The conspiracy charge has been fully litigated. The jury made a final judgment and was made quite clear by the statements of juror number 4 that nothing else came into play as the conspiracy just wasn't there. So this is a very unique circumstance. This isn't a game. And then the second one was for prosecutorial misconduct. Again, you got checks and balances where an executive branch is doing things in violation of their own rules, and a judge is supposed to check and balance that. The check looks like fraud, and the balance got a giant thumb on for one side. The statements made were completely disappointed in the verdict. It's really funny because most times you hear when a jury makes a verdict, the executive branch says, "Well, justice was served. Justice was served. This is our system of justice, and justice was served." The rules for prosecutorial misconduct say something to the effect of the statements made, making extra statements that serve no legal purpose. So disappointment in the verdict serves no legal purpose whatsoever. To the king saying, "Well, I'm very disappointed in these peasants because they found the wrong way. But don't worry, we're going to put in another team, and I don't want to be disappointed in the next team." Again, the game, right? So I'm disappointed in these players because we lost our game. But don't worry, I'm going to get another set of all-stars, and I don't want to be disappointed in you, so you better find a better verdict. There's no legal purpose for that. It's a Sixth Amendment violation of a fair trial. It's a violation of Department of Justice rules, and it's a violation of the American Bar Association's model for the rules of ethics. And again, this isn't a game. These statements simply imply that once the government gets some stronger players, that they don't want to be disappointed in how they play the game. And in the first paragraph of the government's response to the prosecutorial misconduct and the statements that they made to the media, they nearly make the entire defense case. On January 2nd, 2016, Defendant Patrick and several others led a group, let's put that word in there, to the Malheur National Wildlife Refuge. They quickly established a media operation and held almost daily press conferences. Defendant Patrick and his co-defendants gave multiple media interviews during the occupation. The occupation garnered significant national and local media attention. Well, of course it did. Because if you're going to use your First Amendment, the First Amendment of the Constitution, freedom of religion, the freedom of speech, the freedom of press, the freedom to peacefully assemble and petition the government for a redress of grievances, that's exactly what you would do. Most people who are breaking the law or doing a conspiracy don't invite the media to come in and hold press conferences like that. So what they're saying is, to justify their prosecutorial misconduct, let's point out that these defendants, in their exercise of the First Amendment, that we're now alleging is a conspiracy, justifies us saying we're entirely disappointed, which serves no legal purpose, in our players that were sitting on the jury and how they played the game. You know, their opening statement basically says, well, they were using their First Amendment, but we called it a conspiracy, but now we need new players to convict them of what we want to convict them of. And again, it's a violation of the Sixth Amendment, fair trial, you know, tainting the jury with their disappointment. It's a violation of Department of Justice rules, and a violation of the American Bar Association. And if you had a government that still believed in checks and balances, that and a separation of powers, that one branch checks another, they might do something about it. I don't see nearly any checks and balances whatsoever. I mean, we've come full circle. I told the judge at the very beginning, Your Honor, she's reading me rights. I says, Your Honor, I understand I have no rights at all, and you're the federal government, and you can do whatever you want. Meaning this whole thing is federal government. There's no checks and balances anymore. So the motions that you put forward is basically pleading with the judge. Judge, there's checks and balances. But she didn't even want to hear oral arguments. She's got this. Motion's denied. Moving forward. I don't, the fact that you didn't get, even 5 days very early on is fair. But now the government lost, and they're going to need 6 weeks to lick their wounds and figure it out, and that's fair. Jason can't have 5 days, and he's the accused. Can't even give him 5 days. But we'll give the government, with all its resources and all its people and all its time and all its energy, well, they're going to need 6 more weeks. And somehow that's fair. So there's no check and balance. The last hope you have, the last hope there is a jury of your peers. And one thing that was very telling in the first trial is you have a former government employee that made it through and sat on the jury, who was going to throw a monkey wrench in the whole thing. And as the government unconstitutionally continues to grow bigger and bigger and bigger and bigger, and there's more and more departments and all kinds of things, and there's more and more government employees, how many more will then be sitting on juries playing the game and the disappointment? It's the last check and the last balance. But as the government just continues to grow, I don't even know how long that'll be there. But my hope is in the Lord, and I stood up. I love my neighbor. The Hammonds are still in jail. That's very disappointing. There's a new administration, and perhaps they'll begin to check and balance things. But I sure don't see it yet. But those are some of my oral arguments. I was a little bit more prepared yesterday, but oral arguments were denied, so I thought I'd make them here today. Trial's coming up February 6th in Nevada for 19 people charged there. Trial coming up here February 14th for at least 7 people in Oregon. And the fight for freedom never sleeps. I'm Jason Patrick. Peace.